Hello, good morning. Happy Saturday. My name is Megan Mays, and this is Being Civil in Minnesota. I come here Saturdays at 10 to talk about family law rules and issues with the court system. I am an attorney licensed to practice law in the state of Minnesota, but this does not make me your attorney, nor does this constitute legal advice. I like to do this so that people have a good place to start when they're having to navigate the family court system. Today I had somebody ask a question about social early neutral evaluations. I'll call them SENEs for today for short. They posted the question in Facebook, our Being Civil in Minnesota group, so thanks for doing that. You can then watch the live podcast on the Being Civil in Minnesota YouTube channel. So there's about 40 some episodes. This is just one of many topics I cover. Social early neutral evaluations can be, the process can be very county specific or judge specific. So you'll want to make sure that you understand your county and judge's position on social early neutral evaluations. Typically, this is going to be set up during something called an initial case management conference. That is an initial hearing where the judge will invite the parties to come and discuss what their issues are, and we'll try to manage the conflict, meaning what issues can we resolve, what issues do we have to reserve for trial. That usually happens within the first month or so after a case is filed. The reason why is that this is supposed to be an early process. You cannot be forced to participate in this process, which is an alternative dispute resolution process, if you or your kiddo are victims of domestic abuse. The reason for that is because there's typically an imbalance of power. The evaluators are going to be neutral, meaning that they're not going to be providing advice or resources to one party or the other. But it still can be very intimidating if you're in the same room as somebody who had committed acts of domestic or sexual abuse. So that is something to be aware of, that if you have experienced that in your situation, to bring that up to the court if you're uncomfortable. There are still individuals that want to try to resolve matters on their own, and you can still participate in the process. But there are a lot of considerations to take before that is done. You want to make sure your physical safety, you want to make sure that you are prepared to understand the process and advocate for yourself. Now, these are very voluntary processes, so you do not have to come to any agreement in them whatsoever, although it is a really good time to explore people's reasoning behind why they want what they want, what that looks like to them getting what they want. They may say, I want 50-50. Well, I don't know what that means, and I'm an attorney. Are you asking for 50-50 decision making? Are you asking for a 50-50 schedule? Oftentimes there can be a lot of miscommunication in just the words and terms that people are using. So it can be a really good place to explore that. Social early neutral evaluations only address custody and parenting time issues. They are not going to address the financial or child support or property kind of stuff if you're in the middle of a divorce. The process is going to typically have two neutral individuals that come from a child developmental background, psychology, child developmental, and one from a legal perspective, retired judge or a attorney, and they're going to have a background in family law. And so you're going to get kind of two different sides of an evaluative perspective about your situation and what they think maybe a judge might do or options that you guys might have. You can look up people who are registered and providing these services on the Minnesota Judicial Branch website. There is an ADR, which stands for Alternative Dispute Resolution roster. And you can go there on the Minnesota Judicial Branch website and kind of see which providers are providing these kinds of services. Some counties have a list or a coordinator. If you're lucky enough to be in Blue Earth County, we have a wonderful coordinator that helps get these set up. So usually it's a man and a woman. They want to get different perspectives, different backgrounds, so that the information and evaluation can be as broad as possible. Purpose is to reach agreements, reduce costs. The cost for this process will vary, but it's going to be significantly less than going to trial immediately. It can eliminate conflict or lower the conflict by resolving some issues, even if not all of them can be resolved faster. And you'll get feedback on is what you're asking for realistic. There are presumptions in the state of Minnesota, and how realistic is it that what you're asking for can be granted? So who's going to be there? Participants, their attorneys, if they have them, the evaluators, and an interpreter. If one of the individuals has limited English proficiency, it is very important that they are able to understand and actively participate in the process. What does an SENE look like? Well, I've said it can take a couple hours, typically 3, sometimes 4, sometimes less or more. The providers will give you an introduction. They'll give you information about them and their background. Typically, they'll invite the parties then to provide their overview of how they see the issues that need to be resolved and what they hope to get. You can bring in notes. You can write something up ahead of time if you feel like you're going to not remember something or get sidetracked. This isn't meant to be a 45-minute monologue about all the things. History is important to explain to the providers how we got here, but that bad behavior or some of the bad behaviors, they're going to want to, acknowledge those behaviors, but what can we do about it? How can we enhance your life to be better based on the concerns that you have? Is it eliminating communication or limiting it? Is it not having any contact with the other parent for safety concerns? Maybe exchanges are done at a supervised center or law enforcement or a Casey's with a camera. So they can help with some of that. So they'll hear one side's presentation. They're going to ask you to be respectful. If the other person is saying things that are untrue, and that's very possible or likely that you're not going to agree with everything that they say and how they describe how you got here, but try not to interrupt. You're going to have an opportunity to talk, and if you guys were able to agree on how you got here, you probably wouldn't need the assistance of the professionals. So you're going to hear things that annoy you. You're going to hear things that are inaccurate. You just have to be prepared to present your truth and the reason why you think that what you're requesting is better for your kiddos. Once they hear from both of you, they may ask some additional questions. Maybe you forgot to give them your work schedule or what time you have to leave the house in the morning, or if you have stepkids. Then they'll typically take a break and then come and give feedback where they evaluate what they've heard and they say, okay, based on what we've heard, this is where we think a likely settling kind of place is going to be. And then at that point, you can ask follow-up questions of them. You may want to provide more information. You may want to take a break and talk with your attorney. Really dealer's choice. Some parties stay in the same room and then just discuss it openly. Some prefer to have more of a candid conversation with their attorney before they want to reveal their position to the other side. There's usually going to be a deadline set by the court, meaning the court's going to want you to participate in this process within a certain number of days. So once you get that order or you've told the court that that's what you're going to do, reach out right away. You don't want to be in a position where you've delayed so long that you can't complete the process within the period of time set by the court. And it's confidential. So you're not going to be able to call the providers and be like, you heard them say that, yeah, they weren't a great father that summer after their car accident. Okay. Uh, you can't call the providers to testify about that at trial. It's meant to be a confidential process. The only thing that the providers are really allowed to tell the court is, was the SENE successful at resolving all, some, or none of the issues? That's it. What you can do is to set yourself up for success, is prepare. The judge is going to look at the best interest factors, and that's what these social early neutral evaluators are also going to look at. What is best for the kiddos? They're going to come at it maybe from different perspectives, either legal or social or developmental, but a lot of the factors are going to be the same. And so focusing on keeping it about the kids. I always like to have clients bring a picture of the kiddos. I think it can refocus and get people focused on less of pointing fingers at the other party and really like, okay, yeah, we're not together for a reason, but we are having to be in the business of raising kids together, and I hope business is good. If you have any questions or experiences that you want to share, you can pop them in the chat or ask them on the Facebook group, Being Civil in Minnesota. I'll come here next Saturday at 10 to cover another topic. You can catch the episodes on the YouTube channel, Being Civil in Minnesota. Let me know what you think and what your questions are for next week. I hope you have a great rest of your Saturday, and I'll see you next week. Bye.